right, I'm going to call everyone back. I'm going to interrupt your lunch here because we're going to talk about restrictive covenants. Before we dive into that, Sam, are you able to make an announcement now?
Folks, please join me in thanking our dining staff for the terrific work. Thank you.
Next to me, I have Davida Perry, who will be your afternoon moderator. So after I introduce this panel, I will sit down. But it's been really great to talk with you all this morning. We're going to hear from this panel on restrictive covenants. We have Gary Friedman with Safarth, Todd Gutfleisch, who's a plaintiff's lawyer with a background in the financial services industry, and our commentator is Daryl Leon from Baker Hostetler. Please give them a round of applause.
Okay, can everybody hear me? Is that good? Yes? The only slot that's worse than the end of day 2 in a 2-day symposium is the lunch hour. So, but not to worry, there will be a quiz. Sam will be grading them, and you guys are not going to get the grade inflation that is so prevalent in 2025.
It's going to be open book. You can use AI.
Yeah. In any event, so we're here to talk all things restrictive covenants today. I'm going to cover some of the recent developments, sort of take a stroll down memory lane from last year, talk about what's going on now and what may go on in the near future. And I also want to talk about forfeiture for competition clauses, a pretty significant Delaware Supreme Court case that weighed in that's going to have, I think, significant repercussions, not just in Delaware, but outside of Delaware. Todd is going to address some very interesting issues with respect to drafting restrictive covenants and blue penciling. It's not just blue, it's blue, purple, red, orange, green, and black. Lots of penciling. And then Daryl is going to touch on the no poach agreements and recent trends, particularly under state law. So in terms of how we got here, as you all know, the FTC issued a draft rule in January of 2023 with respect to non-competes. A few months later, the NLRB weighed in on the heels of that also, stating that restrictive covenants infringed on Section 7 rights. And then, of course, scroll ahead to April of 2024, and the FTC voted 3-2 on the final rule that you're all familiar with, that essentially banned non-competes across the board with some limited exceptions. The current chair of the FTC, Andrew Ferguson, did dissent, calling it by far the most extraordinary assertion of authority in the Commission's history, and saying that the rule was forbidden by the U.S. Constitution. More about that later. Those strident remarks seem to have been somewhat more muted in 2025. And then Jennifer Abruzzo, who was the GC at the time, issued a memo basically saying that stay or pay provisions and forfeiture for competition clauses were presumptively unlawful under the NLRA. I know you've spent a lot of time on the NLRA over the last couple of days, so I'm going to just briefly go through that. As I mentioned, and as you all know, the non-compete rule was almost a zero-sum game. It did have a carve-out for sale of a business for senior executives, although that carve-out for senior executives only lasted until the rule was due to go into effect on September 4th, 2024. After that, you could not enter into a non-compete with any senior executive. And then there were exceptions for garden leaves. So no sooner was the ink dry than, I'm sure you all know, there were multiple lawsuits that were filed challenging the FTC non-compete rule. The first to file was in the Northern District of Texas. Preliminary injunction was first issued with respect to the parties and then expanded to a nationwide injunction. But of importance, the court held that the FTC lacked substantive rulemaking authority that would be required to justify the non-compete ban, and that the rule was arbitrary and capricious. FTC appealed to the Fifth Circuit, and there it sits. More on that later because it hasn't gone anywhere yet. Then in the Middle District of Florida, court entered an injunction only with respect to the parties, came at it from a slightly different angle, saying that the FTC rule presented a major question under the Major Questions Doctrine, and then Congress had not rendered a sufficiently clear expression of legislative intent to authorize the final rule. And then the Eastern District of Pennsylvania, court denied the injunction, stating that this was completely within the FTC's sweet spot. That case, as I'm sure you all know, has been voluntarily dismissed. So we sit here with the 5th and 11th Circuit cases still pending. More on that in a minute. In terms of the current composition of the FTC, as you know, they're supposed to have 5 commissioners. They've got three members of the 5-person starting lineup, all Republicans, Chair Ferguson, Melissa Holyoke, and Mark Medor. But they have been pretty active in the early going, and not necessarily along the lines that you might think. And again, also given Chair Ferguson's very strident remarks in his dissent. So first shot across the bow was an enforcement action when the composition was 5 commissioners, where they found in this case in January of 25 that this particular no hire agreements in customer service contracts between residential and commercial building owners violates the Sherman Act. Clearly, their focus was on the mobility of lower wage workers, but what was interesting about it was that Chair Ferguson joined the commissioners in a unanimous ruling. He had taken a different position a month earlier with respect to a similar situation involving Guardian Service Industries. I think that the difference between the two, at least according to Chair Ferguson, is that at least in the planned building services case, there were sufficient facts alleged showing anti-competitive activity. February of this year, many of you probably saw this, the FTC issued a memo, and Chair Ferguson specifically announcing the creation of a joint labor task force. The task force was designed to investigate and prosecute, quote, non-compete agreements which employers can use to impose unnecessary, onerous, and often lengthy restrictions on former employees' ability to take new jobs in the same industry. The memo is quite clear that the task force is focused on non-competes, non-poach, non-solicitation, and no-hire agreements. Interestingly enough, the task force memorandum took a page out of, frankly, the Biden administration's NLRB focus on traps, and basically has said that labor contract termination penalties are unjustified fees, and again, the focus is on lower wage workers. But interestingly enough, the question is, what will happen to forfeiture for competition provisions in the eyes of the FTC? That's to be determined. Recent public statements, to the extent you're interested in reading tea leaves, on X, Chair Ferguson stated that the GOP is a workers' party and that the GOP has their backs. Similarly, Commissioner Medor indicated that the FTC should focus on non-compete agreements in employment contracts, adding that non-competes have been overused and abused. Sounds like Clyde Frazier, but he definitely is focused on them more broadly. No hint of whether it's at a certain wage level. And remember the very strident dissent that Chair Ferguson had to the non-compete rule in 2024, where he said that non-competes can promote an employer's investment in its employees by reducing the risk that a rival will ride freely on those investments by luring employees away before the investing employer can recoup the return on those investments. Just a quick note, the chair could have dismissed both appeals. Both appeals were obviously filed during the prior administration, but on March 7, 2025, Chair Ferguson directed FTC lawyers to file a stay of 120 days so he could contemplate how he was going to proceed with respect to those appeals. At a Harvard University presentation, he said, "My view is that the commission needs to decide whether it's a good idea and it's in the public interest to continue defending the rule." I don't think we should spend much time on what if these proceed. If they do, I think the Fifth Circuit is probably more likely than not to affirm the lower court's injunction. And if it were to wriggle its way to the Supreme Court, it might not survive under Loper-Bright. Just a quick word about activity at the NLRB. The acting GC, William Cowan, has rescinded various memos. But one of the things that remains still good law, the memos that Jennifer Abruzzo had issued with respect to McLaren McCombs have been rescinded, but the case itself has not. So to the extent you've been using those provisions in your agreements, McLaren McCombs is still good law. Not likely to see a lot of enforcement activity, one would think, with respect to that, but it still remains good law. Quick point about congressional legislation. Interestingly enough, the sort of rare bipartisan legislation, the Freedom to Compete, the Workforce Mobility Act, which will ban virtually all non-competes, introduced in 2023 by Marco Rubio, and then the Freedom to Compete Act, which is designed to address non-competes at entry-level, lower-wage workers, which we've seen certainly across the board in terms of state law. Right now, no activity. I think this administration has bigger fish to fry. Remains to be seen where that's going to go. Just wanted to pivot quickly before I turn over the reins to the forfeiture for competition issue. As I'm sure you know, employee choice doctrine or forfeiture for competition allows the departing executive to choose whether the juice is worth the squeeze, in essence, whether they will take the benefits and be restrained or forego the benefits and have to proceed accordingly. And so it relates to forfeiture and clawbacks. What's interesting, and we'll talk about this in a minute, everybody's familiar with forfeiting equity rights, but the clawback piece is quite interesting because various states have different approaches with respect to clawback, and that's something that my colleagues may actually talk about in a minute. Cantor Fitzgerald, that was a case a couple of years ago, Delaware Supreme Court. That seemed like sort of a logical conclusion. 6 former partners of Cantor, highly compensated, big equity in the business, and pursuant to the Delaware Limited Partnership Act, they sought a declaratory judgment saying, hey, look, my forfeiture for competition clause is invalid. The Delaware Chancery Court said, no, you have to review this under the standard reasonableness test, which is geographic scope, temporal duration, legitimate economic interests, and whether it survives a balancing of the equities. By contrast, as I'm sure you know, Delaware law views contracts as unenforceable only if they are unconscionable or in bad faith or subject to other extraordinary circumstances. So what the Delaware Supreme Court said was, no, you didn't quite get this right. Under the employee choice doctrine, we view this under the typical Delaware contract standard. These were senior execs, they were sophisticated, the Delaware Limited Partnership Act, and so therefore we're going to review it under an unconscionability standard. This was not unconscionable, therefore it's enforceable. So enter stage right, LKQ Corporation versus Rutledge, filed actually in Illinois, but for our purposes, governing law with respect to the equity provisions, Delaware law. What's important about this case, very distinctive from the Cantor Fitzgerald case, because this involved a plant manager who was basically described as a member of middle management. Even though he was designated as a key person, he had equity awards that called for both a forfeiture and a clawback if he violated his restrictive covenants. He quit, went to a competitor, and the company sued, saying, yeah, not only do you forfeit everything, but listen, pal, we'll take 8 years of equity awards back. Thank you very much. And so the district court said, no, this has to be reviewed, much like the Delaware Chancery Court did in Cantor. It's got to be reviewed under the reasonableness test, and we look at things like temporal scope and duration, et cetera. And they made a point of saying that, first of all, forfeiture for competition provisions are, in essence, liquidated damages. And so they're punitive in that vein. And also, this was a middle manager, not a senior exec. So they struck and invalidated the provision. Case was appealed to the Seventh Circuit, and the Seventh Circuit then certified 2 questions to the Delaware Supreme Court. Most of the questions that are certified to higher courts tend to be more neutral. These were more leading in nature. If you take a look at the questions that were certified, whether Cantor Fitzgerald's decision precludes reviewing forfeiture for competition provisions for reasonableness in circumstances outside the limited partnership. Basically, what they were saying is, look, answer this question for us. Is this only for partners in a business who are extremely sophisticated, where there's big money at stake, or there are a whole slew of factors that you need to consider? And then the Delaware Supreme Court weighed in and clarified, and this is really the big takeaway for everybody in the room. I think this is going to have ramifications in many other states, including New York, which is a big employee choice jurisdiction. The court clarified that Cantor Fitzgerald should be read broadly, that it was not limited to cases arising under the Limited Partnership Act, and that freedom of contract principles were really at play here, and they needed to be honored. A couple of points of note. Number one is employee choice means choice. It means that you've got to make the choice to leave, not if you're involuntarily fired. Second, they said that the forfeiture for competition provision did not constitute liquidated damages. And another point, which is sometimes lost, is that you can't get injunctive relief under a forfeiture for competition clause. You've got to get it separately in the agreement. And so they did leave open a window, and this is important, saying that, we're limiting it to the facts here, and there may be circumstances when a clawback is so extreme in duration and financial hardship that it precludes employee choice by an unsophisticated party and should be reviewed for reasonableness. So without further ado, I'm going to pass this to Todd.
Okay, so I'm going to be talking about the drafting of restrictive covenants. So how do we go forward here? There we go. So when drafting, and I don't know if a lot of people are in-house lawyers, because certainly when I was in-house, I did a lot of drafting of them. The first thing I start with is the fact that non-competes mostly are disfavored as a matter of law. Certainly in New York, they're disfavored as a matter of law. And there's a number of cases, I cite to a couple here that state that they're disfavored. There is a recent trend, Darrell's going to talk about it, at least of a few states, which go the opposite way, actually, which is, contrary to what I've always been taught, at least as to non-competes, but this is where we are. So now, the first question I have is, when do you introduce restrictive covenants? The best answer is at the start of employment, or frankly, before the start of employment. So when the worker accepts an offer, and the question that I sometimes put in when I'm drafting it for employers is, do I have a separate agreement or do I include it in the employment agreement or the offer letter? I don't think it makes a difference. Some people like to draft separate confidentiality, non-compete, non-solicit agreements. frankly, just because when you go to court with it, if you ever have to enforce, you have one simple agreement. You don't have all this stuff that says the person's going to be paid X and have all the other stuff that gets mixed into it. Can you introduce non-competes during employment? And is continued employment sufficient consideration? In New York, the answer is generally yes, and I find that to be the answer in most states, but you have to look before you do so, because there are some states that say you do need additional consideration for non-competes. Common times when a non-compete is, or any restrictive covenant is put in place is when someone is provided a raise or a promotion. And it makes sense, and that's, kind of when you're drafting, what you should be focused on is, does it make sense? Because, that's what you're going to put your lawyer in the place of when he or she has to enforce it. With a raise or a promotion, maybe the person's privy to the business plans of the employer, confidential information of the employer. That's what that's in enforcing a non-compete, that's what you're going to have to, put forth before the court, because to me, it's always been, and I think most courts will say, it's, what's the protectable interest? Just because the person gets paid an exorbitant amount of money, if there's no protectable interest, it may not be enforced. I'm not going to say that a judge won't be influenced by the fact that I'm arguing as the lawyer, that it's not enforceable, but the guy makes $10 million a year. A little hard, for the court to feel sorry for the person in that sense. And courts decide these as a court of equity. Common, as we see in the Delaware cases, with a bonus or an equity grant, whether to enforce it or whether to put it in there. I've had issues, though, come up in recent times where people are paid discretionary bonuses or even not discretionary bonuses, quite frankly. And just before they get the discretionary bonus in February of the year after, the employer says, oh, yeah, and please sign the non-compete also. Creates a little bit of a problem, especially where the employee, I've had these calls before, is about to resign after they get their bonus and then suddenly is faced with, what do I do now? But certainly, it becomes a little more difficult to enforce. Well, if the employee doesn't sign it, it certainly becomes difficult to enforce. What are the types of restrictive covenants? Easiest one is protection of confidential information and trade secrets. Of course, you should be protecting those. Protection of intellect, the inventions, should actually be enforced. Garden leave provisions. Always interesting. Everybody assumes that they're enforceable. Not always. First of all, you can't make somebody, in my mind, you can't make somebody work during a garden leave provision. I know sometimes employers have argued that and don't think that a court would actually force somebody to provide services during that period of time. I've never seen it. The other issue is garden leaves are generally short-term in nature. So they're just enforced because, number one, each employer, especially I do a lot in the financial services, they generally, if they don't require a joining employee to to comply with it, maybe it won't be complied with when one of their employees leaves. Second of all, of course, when it's a 90-dayer, if I suggested to my client we should challenge the garden leave provision, they'd probably fire me for the free 90-day vacation. Non-competition covenants are obviously very common. Restrictions on soliciting or servicing, should be servicing clients, customers, or business partners, that's very common also. Prohibitions on soliciting or hiring employees, again, common. Non-interference provisions, seems pretty easy to enforce that, saying you won't interfere with a business relationship. And then, of course, we have the forfeiture, clawback, and liquidated damages provisions. And I think in those orders, forfeiture is certainly simple. And I always tell the employees, it's easy for a company to hit the button and cancel your deferred compensation. It's a little more difficult for them to go out and sue you for it. So what types of employees should in non-competes or restrictive covenants be put in place against? Executives, likely. Salespeople, they're your face, right? So the employer has a good argument that those are the persons that, we've spent lots of money introducing the persons and developing the relationships with the clients, and we need some limited period of time to kind of catch up. Professionals and with technical expertise and talent and artists, yes. Clerical workers, now you're working your way down, and it's a little more difficult to enforce. Where's your protectable interest for a clerical worker? Low-wage workers, then you're going to get into undue hardship, which is part of a analysis. Lawyers, us lawyers were smart enough to put in our ethics obligations that it would be a violation to enforce against lawyers. So we got ahead of it with respect to that. But it doesn't always apply, by the way. There is an argument that in-house attorneys who are doing business roles also, there's been, at least what I found is a split on the law on that issue. Medical employees, usually they're geographically limited, but not always. And this is where you get into public policy considerations. So where do you include restrictive covenants? I just said employment agreements and offer letters. That's your best place to do it, probably. It's this is what somebody's accepting when they're taking your employment. During employment, we've discussed that, promotions, employee handbooks and code of conduct. I've seen them in there, and it kind of feels like I'm saying they're slipped in there sometimes, and that makes it a little more difficult, in my mind, to enforce. It also may be difficult to enforce a restrictive covenant in a handbook because there's plenty of case law out there that says that the employee can't frequently enforce the handbooks as a contract. So you turn it around the other way, it makes it a little more difficult. Also, most of us who draft handbooks put in warnings in there that says this is just guidance and it's not a contract with the employee. Separation agreements. So yeah, I mean, it's generally going to be viewed differently in a separation agreement, at least in New York, with respect to it. If you're terminating an employee in New York, it's difficult to enforce any restrictive covenant, or at least a non-compete. And there's a bunch of cases out there, at least in the first department. Actually, there are, I think, third and fourth department cases that say you can still enforce against a employee who's been terminated. The first department, certainly, in recent times, at least since 2015, I think it was DeLuca versus Buchanan Capital Markets, and there's also the Colchins case, which we did, which the non-compete is not going to be enforced.
These were terminated with cause?
No, without cause. If you're terminated with cause, I believe it still would likely be enforced, because if you're, then I could just try to get out of my non-compete by going into the office and cursing out my manager and saying, oh, I was, he terminated me. Bonus and equity, agreements are commonplaces to put them in, and probably a little more enforceable. If you ask me, courts are going to look at that and say highly compensated, like they did in the Delaware cases, and in LLC and partnership agreements. So I'm not going to run through everything in the state law issue, and it's probably hard to read because I made it too small. But it's a good place, though, to look at the Massachusetts, and we also have the Colorado one, which I'll follow with, is just when you're drafting on things to think about. Obviously it has to be in writing and signed. It should state that an employee could consult with an attorney. It probably is a good idea to put that when drafting. If made, before the employment starts, it probably should be made early enough. I've had this happen before. It's really bad when an employee shows up and they're signing all their, general documents when they start, and oh yeah, there's a non-compete in there. It could tend to, get an employee a little angry and maybe even walk out. If made after the employment begins, this is the Massachusetts law, it has to be supported by reasonable consideration. So, that there goes the continued employment in Massachusetts.
What do they mean by that?
I think there has to be some separate consideration. Massachusetts also requires, which I always suggest, is provided to the employee in advance. They say 10 days. It should be and this goes to everything, no broader than necessary. Because if you do it too broadly, too long, length is frequently the issue that's litigated. But frankly, it's, what are you protecting against? And that's where I always start, when I am interviewing an employee or employer to say, what are we protecting against? That's what you have to put in your brief. I recently had one where the brief basically just repeated back to me everything, the boilerplate that was in the employment agreement. I didn't find that very persuasive. I don't think the court would have either, if we had actually reached that, although it was in a brief, it didn't get to the court. Massachusetts has, it should it be for longer than 1 year or 2 years if the employee is terminated for breach of fiduciary duty or took the stuff. Always a thing that if you're enforcing it, that there's low-hanging fruit when the employee does something stupid like takes the stuff. So, it has to be reasonable. Geography, actually, I should go back. Geography is always an interesting one of whether, because many jobs now are not really geographically restricted. Physicians frequently are. Other areas aren't. I'll just flip ahead to Colorado, has similar types of requirements. Colorado also has that it has to be provided to the employee 2 weeks before the earlier of the effective date or the worker accepts employment. I recently had this one where the company wanted to roll out the non-compete and wanted the employees to sign it the same day. The manager went online and said, not a good idea. I think they have to have 2 weeks, notice of it. The big manager thought he was really smart and said, no, they have to sign it anyway. And, today or they're fired, so they signed it. And then about 2 months later, a bunch of employees quit, went to an employer and said not enforceable. And their Colorado lawyer said, probably not. They're probably right. So not the wisest decision. Scope and length, okay, that's obviously the most important when drafting. You have to identify, when you're drafting them, you should really be identifying what's the protectable interest. Length of time, I don't know if there's a litmus test for it. I would say anything over a year is really if you're trying to enforce it, is going to be really difficult to enforce. Should you pay an employee during the non-compete? I always tell people, you don't have to. Right, but the courts, at least in New York, but the courts in New York, frequently you get up before the judge and one of the first questions the judge asks is the person being paid? So, well, I don't think it actually says it anywhere, and I don't think there may be a couple of cases, but not very many that say you have to be paid during the period. If you really, really want to enforce it, you probably should be paying at least base salary and frankly benefits, which is going to be an issue that the employees are going to raise. What to protect? Trade secrets, confidential information. Workforce stability is one that always gets me because I've had people argue this before, and the first time I saw it was only a few years ago. I was like, what is this workforce stability? I don't see a non-compete as workforce stability, and I haven't actually seen it in the case law. I've seen a couple people argue it. Doesn't really get there. Client relationships, absolutely you have to try to. So BDO Seidman is the case that I think appears in pretty much every brief in New York, or it should at least, when you're fighting about non-competes. And you should start with that in the brief, and you should start with that when drafting, which is no greater than required for the protection of a legitimate interest of the employer, does not impose undue hardship on the employee, and is not injurious to the public. I also use the second quote, which I go towards the end, is BDO's clients with whom a relationship defendant did not develop through the assignments or performed direct or substantive accounting services would therefore violate the first prong of the common law rule. So basically what I read that to say, and I've always argued, is you can't tell the person who's coming in to service it, clients or customers that on the way out they can't service the same ones when they leave. So employee mobility, okay, this goes to like drafting and such, and I cited this Wisconsin case because I just found the logic, great for it, which is it said that you couldn't solicit any employee of the company. Very common, you see it all the time. Well, the company had, I think, like 50,000 employees, and the employee argued, what protectable interest is there? And going back to that word protectable interest in there, I don't know like 99.9% of the employees of the company. There is no protectable interest, and the Wisconsin Supreme Court agreed. So that goes to, you should be limiting in all of your restrictive covenants, especially employee non-solicits, where the employee intersects with it, whether they have confidential information, they know the employee's salary, they know the employee's performance. If they don't know that, you're gonna have a hard time enforcing it. There's some conflicting law. I cite a couple of cases about whether a non-solicitive employees would be enforceable. I always use in-ray document technologies, which is a Judge Rakoff case. Judge Rakoff, say what you want, he's pretty smart. And basically what he said is, hey, the employer here, wants the best of both worlds. They want to keep the employees employed, just in employment at will, so they can fire them anytime they want, but yet they want to restrict the employee also. So it's kind of cutting into what I've always viewed restrictive covenants as being used as of late, which is it's kind of an attack on the employer side on employment at will. So it's restricting the employee's ability to quit and find a better job, but it puts the employer in a more favorable position because, as Gary noted in the case with the clawback of 8 years of compensation, who's going to quit their job and be willing to pay back 8 years of something? I don't know how much it was there. In that case, the Delaware case, the person was not exactly a highly compensated employee. I think he made barely over $100,000 a year, which is a fine living, but it's not something where the employer could go hire Gary to defend him. Do you want me to move this over?
No, I'm good. Thanks. Darrell Leon, I'm a counsel at Baker Hostetler in the Trade Secret and Non-Compete Group, and I'm excited to be here in person, which is one of the first in-person one of these I've done in a while. So that's always nice. I can see faces smiling or not. So I'm going to talk to you a bit about the trends that we've been seeing in states across the country. The absence of the FTC's rule has really left what I think we saw last year was a kind of a pause from states in pushing out new regulations. We're seeing states step back in to enforce and to put out new regulations that they want to create in their states. This is leading to really the furthering of the patchwork that those of us in this space, whether or not you represent plaintiffs or defendants, because I think up here on the dais we probably play both sides of the caption on these cases. You're either hiring someone or you're drafting on behalf of an employer. It makes it difficult to stitch it all together. But what I like to do is you can kind of bucket depending on the industry, depending on the wage, depending on the employee classification. There's a couple of ways to think about the ways that states will or will not allow you to restrict the workers in their states. All the sites that I'm going to show you here are either signed, aside from New York, which we'll talk about at the very end, but they go into effect around July or August of this year. So to the extent that you're getting concerned that you haven't updated for any of these, most of them are signed or pending signature with an effective date around July or August. So Arkansas, all that they have done is they've clarified that a non-compete in the restricted physician is void. This is a medical exemption. That's one of the big buckets we see. There's a sort of a common man argument that makes sense here. If you are a patient of a physician, if you're getting specialized treatment, or just your regular person that you trust dearly, you should be permitted to continue to go see that person. It makes sense. It goes back to our arguments about how do you put together a fair and appropriate restricted covenant. What's a protectable interest? Stopping someone from going to their doctor is a tough one to make at times, but obviously employers in that space have a need to protect those relationships. So certain states step in. This is one of the largest areas of specialized employees that are subject to these bans. So Arkansas has clarified this. Colorado has eliminated their low wage threshold for restrictions that impact doctors. So whereas they used to be treated just like any other employee, now that wage threshold won't save you there. Maryland has gone sort of it's combined a few of these notions. If you make under $350,000 as a physician or someone licensed under Maryland's occupational health occupational article, you can't be subject to a non-compete. If you earn more than that, then you can only have one that goes up to 1 year. and no longer than 10 miles from your place of employment. So they have done what Todd was talking about before. They've told you the ceiling about how long and how far you can restrict the doctor from practicing. Utah, I think, is interesting. I listened to the argument here. They've basically created a law that will prohibit healthcare Uber, basically, from restricting people to their platform. So they don't have anyone in mind yet, but to the extent that a healthcare services platform comes into effect, that platform is not allowed to restrict physicians who are on that platform from going to other platforms, or from accepting a shift with an employer at a different facility. I note it as creative. I don't know if it was necessary, but again, that's not exactly what I do. And so that is actually the one of these that is currently in effect as of May 7th of this year. I'm going to start with Kansas here because there's a little less to say about it. There is a whole new crop of states that have popped up with what I will call pro-restrictive covenants, which is a trend that I never thought that I'd be speaking to any group about. Kansas has amended their Restraint of Trade Act, and that, to be clear, applies to non-solicits. That mandates, though, that if the covenant is determined to be overbroad or not reasonably enforceable, the court shall modify the covenant. So that is mandatory reformation of that provision for a non-solicit. Courts across the country, some of them are permitted, is I think more common. Some of them may not. You have Washington State, where if the court rewrites your agreement, you end up getting dinged with fees and penalties. Kansas says that for the non-solicit, the court must reform. Florida, just to be clear so that everyone knows, still not yet the law. As soon as it is delivered to the governor, depending on whether the state senate is in or out of session, it's either 7 or 15 days before he has to sign it. Everything that I have heard, although admittedly I don't talk to too many people from Florida too often, is that this will be signed, but remains to be seen. Florida's Choice Act, which is a tortured attempt to squeeze Contracts Honoring Opportunity, Investment Confidentiality, and Independent Economic Growth Act, basically lays out that if you have a covered non-compete or a covered garden leave, courts are required to issue a preliminary injunction against the employee or their new employer. This is the first that I am aware of actual mandate on a preliminary injunction. Query whether or not there is any separation of powers issues here where the legislature is telling courts what they must do without consideration of the facts, but so that you are all aware, and before you shift all of your agreements down to Florida, a covered employee is an individual or contractor who earns, the expected earning is twice the annual wage of either the county in Florida where the business is based or where the employee is based, depending on whether or not the business is located in Florida or not. I went online. Miami-Dade has the highest annual wage. It's about $70,000, maybe 72 and change. So ballpark, $150,000 low wage threshold in Florida across the board and lower in other counties. If you have a covered non-compete, it may not exceed 4 years. The employee must be advised in writing, and they have 7 days to consider, and they must acknowledge that they will receive confidential information and customer relationships during their employment, and then it has to be reduced by a covered garden leave period. And then for the covered non-compete, I think they both say non-compete. Yeah, the top one is non-compete, the bottom one is garden leave. Again, 4 years, must be advised in writing, and have at least 7 days to consider. Acknowledge about what they will receive, and they, after the first 90 days, the employee does not have to provide services, which means, I guess, presumably that during those 90 days, somehow Florida can compel you to provide services. I don't know how that happens. Employee is permitted to engage in non-work activities during the remaining of that period, and with the employer's permission, they may work for another employer while employed during the remainder of that notice period. So, will this get signed? Indication, I see somebody up on the dais here nodding yes. I have heard others say yes. I try not to read tea leaves. My only comment on this is Matt Gaetz and Lena Khan were very closely aligned on the FTC non-compete rule. That's Florida. There's a whole sort of way to think about these things. I don't know if it'll get signed, but I think folks are feeling good about it. Should you move your agreements to Florida? That I can't tell you, but I'd be happy to after this, maybe for a small fee. So then you see the most common category here, or the ones that at least get the most attention, bans and low wage. I think we can all go back to sort of the Jimmy John's case. You have low-wage employees who are being subject to pretty draconian non-competes. Whenever I talk to clients, I think Todd and Gary as well, you want to understand what that protectable interest is, and you want to understand why it is that these folks need to be restricted. The snapback that we're seeing from the states with low wage and other just outright bans on non-competes is a reaction to that. If you're going to give sandwich workers a non-compete, we're going to tell you you can't use non-competes, or we're going to tell you you can't use non-competes with anyone below a certain wage or in an employee classification. So Wyoming got a lot of attention because they banned non-competes, but there's a carve-out for executives and management personnel and officers and employees who constitute professional staff. That feels like the exception that swallows the rule. It feels like maybe they kind of just wanted a low wage threshold and they didn't, and they wanted something a little bit splashier. I don't know, I haven't seen it tested yet, but it's why Wyoming concerns me less obviously than a state like North Dakota or somewhere else, Minnesota or California. Virginia already had a low wage threshold, and it already captured interns, students, apprentices, trainees. It has now been expanded to FLSA non-exempt employees. So to the extent that we didn't get you before with one of those, we've got it now. Oh, did I not have that up? Sorry about that. Okay, New York, introduced, not just recently out of committee on the Senate floor. I have not seen it put up. I haven't heard any movement beyond that. It's been on the floor for about a month now. But New York legislature has introduced a bill, anyone less than 500,000 may not be subject to a non-compete. This is presumably in reaction, the belief was back in 2023 that Governor Hochul would not sign the non-compete law because it did not include a low wage threshold. The rumors were that she wanted somewhere in the 200 to 250,000 range, and she could not get that. Now it's 500,000. What that does for upstate versus downstate New York, I think you all know as well as I. We will see if it gets any traction for those keeping score. Last time New York passed its bill, it was right towards the end of the session and over the early June period as well. So we'll keep an eye on that. So drafting considerations, this is back to Todd.
Okay. I think we only have a couple minutes on this one, but one of the issues that we find is that people draft. You should draft what you'll enforce. If you kind of hide it, and we've had some of these before where people, they all of a sudden an employee leaves, they have no idea. I can't tell you the amount of times that happens. It's probably not a good idea. You should probably put it in a place where the employee knows it occurred, they have to sign it. But one of the big issues is the deterrent, because I think more often than not, I think if we challenge the non-compete, the employee wins. That's, they're disfavored as a matter of law. But the reality is that employers, the subsequent employer, says, I'm not going to hire the person because, I don't want to deal with it. It's the deterrent effect. Sometimes they'll, if I have, a very high wage earner, frankly, they may actually pay the person to sit out, but they don't challenge it. And that deterrent effect makes it just, to the effect of just draft it as broad as you want.
Which we're seeing the snapback again from the states there. Washington, if they reform the agreement, so even if they enforce it, they just reform it, there's fees and penalties. Colorado tried to make it a criminal misdemeanor for an overbroad non-compete. So just like they're giving you straight restrictions that you have to follow wage and whatever else, there will also be penalties in some states if you've gone overbroad and just for the deterrent effect.
The criminal might be a little, further than I would probably want to go, even me representing the employees. But I do think that there should be provisions if you're going to really enforce, draft it to say that the employer who tries to enforce it, if they lose, has to pay the attorney's fees, because it really becomes an issue for employees in fighting these. if they have to pay their own fees. So if you have your $1 million guy, okay, we're going to wrap up.
Can I just interject one moment? I was the chief reporter for the restatement of employment law, and we have a provision in it that says if you are trying to enforce a covenant which is unenforceable, you're subject to a public policy tort cause of action. So something to take a look at. Also, a number of states have adopted the Restrictive Employment Agreements Act from the Uniform Commissioners. Have you seen that?
I have not.
I think Utah did, and so that's something to look at. The Uniform Commissioners have come out with a restrictive employment agreements provision. At least 3 states that I've seen have adopted it, maybe more, so it's something to take a look at as well.
Well, certainly, a lot of non-compete agreements, and I know we have to wrap up, a lot of non-compete agreements have that the employer drafts in there that if you don't abide by it, you have to pay the attorney's fees if you lose. Certainly, California has a provision that says if that a type of agreement applies in any agreement, the opposite also applies. So the employers automatically put themselves up on their own provision. Certainly in arbitrations, that's permitted, where I've seen the attorney's fees provision get turned around on the employer who drafted it. But in general, probably not.
Thank you so much. Please join me in
Thank
thanking
you.
these wonderful panelists.
Thank you. Interesting area.